All right, so good afternoon, everyone. I am Kadeem Morris. I am a staff attorney in the housing unit at Community Legal Services. Welcome back to our weekly edition of Tenant Tuesdays at 2. We are happy to be here with you on an albeit rainy day and share with you some information about tenants' rights. Tenant Tuesdays at 2 is a weekly conversation about issues that tenants are facing in light of COVID-19 and just general tenant protections around the eviction process. This weekly conversation is sponsored by the Philadelphia Eviction Prevention Project. You can learn more about the Philadelphia Eviction Prevention Project and our services by visiting www.phillytenant.org, or if you'd like personalized advice, information, or would like to seek out possible legal representation, you can contact the Philly Tenant Hotline at 267-443-2500. So I am joined today by Tony Abada. He is a paralegal here at Community Legal Services, and he's joining us to lead our conversation about repair issues that tenants might be facing at this point in time. We're going to start with a bit of a recap, going over some of the things that we have talked about previously, just so that everyone can be up to speed, because I know this is now our third bite at the apple, and some of the information I think is worth reiterating to people. So Tony, you are free to say good afternoon so that everyone knows that you're here, and then we'll get started. All right, so right now, the state of the court process is that courts are closed until at least May 4th. There may be some potential action from the Supreme Court at the request of the governor to make an extension of that moratorium, but the moratorium right now goes through May 4th. So that means that evictions and lockouts can start again on May 4th. So if you've not previously been through the court process, that means that your landlord can file against you on May 4th. If you had a case that may have been previously postponed, that means that your case could be rescheduled for any time after May 4th. If you are in the appellate process, the Court of Common Pleas is also closed through the 4th, and you'll be notified when your case will be rescheduled if it hasn't been previously scheduled. The Fair Housing Commission, which is an alternative avenue that tenants can pursue to bring issues about habitability, general disagreements with landlords around their housing, they are also now working remotely, and they're subject to the governor's stay-at-home order, which is right now until May 8th. So once that order is lifted or extended, we'll see when they will again start having hearings in person, and that information will be updated on phillytenant.org. So once again, if you have a specific legal question or you would like legal advice and information beyond the scope of this conversation, feel free to call 267-443-2500, and one of our advocates will return your call within 24 to 48 hours. So I want to recap really quickly the eviction process. So the evictions is one or two processes by which a tenant can be removed from their housing. The process generally involves notice to the tenant, usually a notice to quit or notice to vacate, and the filing of an eviction case in municipal court. As I mentioned before, right now we're at the stage where the court's closed and no new filings can be made. So come May 4th, if the order isn't extended, your landlord may file an eviction complaint, and that will kickstart the eviction process. After you get an eviction complaint, there is a process by which your landlord has to schedule that with the court, and it gives you a date to come into court. Usually, let's say 2 to 3 weeks after that complaint is filed and you've been served with that complaint, it's scheduled for you to come to Municipal Court, 1339 Chestnut Street in Philadelphia, and that's where you'll have the opportunity to attempt to negotiate an agreement with your landlord, appear before a judge, or go through the mediation process. Those are basically your three options on that day. So at that point, the tenant can seek out legal representation. The Philadelphia Eviction Project has a lawyer of the day that's generally available in the courtroom that's staffed through our partners that can help tenants through the court process. There's a courtroom navigator that can provide information, and there's also the court's own mediation process that's present there, where tenants can go and seek out resources because I imagine a lot of people who are now going to be in this eviction process because of COVID-19 have had no prior dealings with municipal court and its process. So that is something to be aware of in terms of the structure. If you do appear before a judge and a judgment is issued against you for an eviction, there is a 21-day writ process. This also applies if you come to an agreement with your landlord that says you move within a certain time. The minimum time between the date of an eviction hearing and a lockout being scheduled is 21 days. And that is because your landlord has to file 2 separate pieces of paper, a writ of possession and an alias writ, before they can legally remove you from the property. So if you go to court, let's say May 15th, your landlord still has to wait 21 days before a lockout can occur. So that's a built-in window for you. So who can be evicted? Essentially, any household member who is living in a home pursuant to a lease can be evicted. If you are not a household member, you can go through the common pleas process, which is a similar notice process opportunity to negotiate with your landlord beforehand. But generally, if you are living in the house and there's a lease, written or verbal, you go through the eviction court process. And at that point, you'll be able to raise any defenses that you have to what your landlord has filed. An eviction filing will be done on the basis of one of 3 things. There's non-payment of rent, meaning that you are living in a leased property and haven't paid rent for some period of time. There's termination of term, meaning that you are at the end of your lease term with your landlord, whether it's an agreed upon 1 year, 6 month, or month-to-month contract. And some party in that lease, usually your landlord doesn't want to renew the contract beyond that date, or there's a breach of the lease agreement. A breach of the lease agreement can be your failure to comply with any term of the lease. It can be a violation of the pet policy. It can be having more people in your property than authorized on the lease. Whatever it can be a failure to get renters insurance. There's several things that are outlined in your lease that you're required to comply with. And when you don't comply, your landlord has the option to file against you in municipal court on the basis of breach. So as I did explain, there's a 21-day period between you getting a judgment or an agreement to move out at a minimum that your landlord would have to wait for you to get locked out. So if you think about it, you could potentially say that there's a month after May 4th, where things will have to start working if everything gets scheduled automatically. That may be longer, because if you had a case that was scheduled and continued because of COVID-19, that has to be rescheduled by the court. The court will, of course, notify you when that date is, but there's a minimum 21 days from the day that you appear in court and the day that you can be locked up. Now, it's very important to note that a tenant cannot be locked out without first appearing in court. Any act by the landlord to remove you from the property without you having appeared in court and either opted to go through the mediation process, seek out an attorney, or appear before a judge at that point in time is considered an illegal lockout. So if your landlord shows up at your home and tells you that you need to leave today or tomorrow, that's illegal. If your landlord shuts off your utilities in the basement, that's also considered an illegal lockout. If your landlord changes the locks on the front door so that you no longer have access to the property, that's also an illegal lockout. We discussed this at more length last week on our prior edition of Tenant Tuesdays at 2. So there's all of that information there that you can go to. But what's the real takeaway and the important stuff for you to know right now is that if you are the victim of an illegal lockout, we've seen some uptick in that activity, particularly since things have been closed. You should call the cops if it's happening while you were there. If it's not happening while you were there, you still have the option to reach out to the cops and file a police report so that they can get that information and you can have a document that will allow you to get back into your property or allow you to file a basis for your emergency petition that you can file to the court to get possession restored. So that's just a brief recap of where we are in terms of what a tenant's rights are, what the actual legal process is for you to be removed from your home if you do get to that stage and can't come to an agreement. And right now we're going to shift focus and I'm going to bring in Tony to talk about repair issues. So Tony, can you briefly explain what a tenant's right to repairs are under the general circumstances of a lease?
Hello, Kadeem. Thanks for having me on. I think we might be pausing for just like a couple seconds to see if we can get our Facebook Live up and running. I see the recording is back up. It looks like we're getting the go ahead to just go ahead anyway. um, so yeah, I think it's a really important topic, just in general, talking about how tenants can access repairs in Philadelphia. I think that, we we have here in Philly a housing stock that's pretty old on average. Over the last 10 years, we've lost a bunch of more affordable units, like 13,000 units are more affordable, while gaining sort of 6,000 units at the high end. What that's meant is that the pressures um, on tenants and in situations where we're renting is that we're willing to put up with more in terms of not having repairs, and we're paying more because we're starting to see sort of a shortage of affordable housing in the city. So that's one of the reasons that I think talking about the tenant right to repairs is really important in understanding how we can access those resources. Um, so I can just jump right in. I don't know if you want to, if you had any initial questions or.
Give me 1 second. We are interlinking with our live feed and we should be good to go in about. There we are. We are now live.
Great. Let me know when you're ready.
So we are live, Tony. So I think we can backtrack the conversation just a little bit and talk about what's generally going on. And you did have a good intro about what the housing stock in Philadelphia is like and why tenants now more than ever are in need of getting critical repairs done. So do you want to start from there?
Oh, sure. Yeah. So a tenant right to repairs here in Philadelphia, it's especially important because of the struggle that we have, as you were just highlighting, with sort of the lack of affordable housing and tenants being sort of forced to put up with conditions that we might want to advocate and push for, but we're under this crunch that we're trying to find an affordable place to live. There are a lot of folks out there, especially in private housing, who often put up with conditions that they'd like to get some repairs done, but they're a little concerned about sort of the availability of housing. So that's like the larger framework that I like to have the conversation about advocating for repairs within, just so that we're sort of realistic in what people are dealing with on the ground. But sort of from a legal perspective, so yes, as tenants, we do have the right to a safe, habitable living space. So that means that we can get the repairs that we need. We're not responsible for those repairs. Although sometimes landlords try to say that tenants are responsible for certain repairs, and sometimes we'll even see that in leases.
So how does a tenant go about advocating for repairs that they are entitled to? What's the first step that they should take in that conversation?
Yeah, it's a good question. I think the biggest part is sort of understanding that anything that we're requesting in terms of repairs being done, if it's possible, we like to make sure that we can do that in writing or some way to be able to track it through text messages, emails. So making repair requests in writing, even a formal letter can be a good place to start. And then it's really important to document what are the conditions that you're dealing with. So if it's an issue with, say, a leaky roof, if you can take a photo of the leak happening or the damage that resulted from the leak, to start to build sort of your story and the history so you can kind of tell what's been happening. You know, at any point in sort of the escalation process, the landlord could simply make the repairs. So you're just kind of preparing or laying the groundwork if you need to escalate going forward.
So you said document the repair issues and make that repair request in writing. Is there a timeline that tenants should allow to elapse before they attempt to, let's say, fix the repair themselves? What does that look like for the average tenant?
That's a good question. I think directly answering your question, it really depends on the type of repair that you're dealing with. So obviously for more severe repair issues like not having heat in the winter, or having an active sort of leak in any part of the house, those would be considered emergency repairs where you'd want a response within 24 hours because it could cause further damage to the property, obviously being conditions that you just can't live in. So before I forget, I wanted to also mention that all of this information, at least an outline of it, is available on phillytenant.org. We have a really good flyer that walks you through step by step in terms of what to do requesting repairs in the escalation map. And another piece that I think is really important when you are asking for repairs is often we see the other side of things where landlords are saying the tenant won't allow access for repairs. So while you're requesting repairs, you want to make sure to document those requests. You want to make sure to document the conditions, and then also just be available for repairs or allowing access to the unit to actually get those repairs done. If there's anything you can document too to say that you were available and accessible and the unit was accessible as well, that could be helpful in the future.
That I think is some very great information in terms of, I know that people request repairs and schedules changes and things fluctuate and everyone's not always available to come in and have a repair done at a particular time. So I think we want to pivot a little bit to, so I think there's an important question, and we're gonna take a pause at the end to answer those questions. I see that there's at least one question in the chat box. We see them, continue to put them in the box, and we will get to them as they come in. Is there a distinction, Tony, just to lay the groundwork? Is there a distinction between the way someone who lives in, let's say, a private housing development versus someone who lives in subsidized housing should go about requesting a repair?
Yes, there are some significant differences depending on the type of housing that you live in. I think the big categories are what you just outlined, which is, do I have a private lease, which means that I pay kind of like market rate for my housing, or do I have some sort of subsidy where I'm living, which means that this could be through a voucher, public housing, or some sort of subsidy, meaning that I pay a little bit less or sometimes significantly less than what market rate apartment costs or units cost. So I think the biggest category is private housing. So that's just your regular straight lease agreement with a private individual, landlord, or a company. And in those cases, we have some different ways of escalating in terms of trying to get those repairs done.
So I know you mentioned that there are different ways of escalating and getting those repairs done. I think we should probably refresh people who I think will feel potentially significantly vulnerable at this point in time, people in subsidized housing, to remind them of what that process is that they particularly should go through. And then we can double back on the private housing issue.
For sure. So subsidized housing, again, what that means is subsidy, or I'm not paying necessarily the market rate for rent. That could include, I guess the first area it could cover is sort of project-based housing or subsidy that follows a building or stays in a building. Many of those sort of protections in terms of getting repairs are actually similar to private housing, except if you know that the Philadelphia Housing Authority or PHA is involved with your subsidy. So for example, if you have a voucher that's linked to a unit, in that case, you may be able to contact PHA. Actually, you can contact PHA. They have a repair hotline, which is on our flyer. The problem is that I actually reached out to them late last week to find out what was going on in terms of Are they coming out to do inspections? An inspection means when an agent from the Philadelphia Housing Authority comes and physically reviews the unit in order to see if there are repair issues. The advantage of having PHA involved when you're having repair issues is that PHA has some leverage, or they can lean on your landlord and say, hey, landlord, make these repairs, or the portion that I pay as PHA, I'll stop paying it. What that does is sort of, it gives us a little bit of an advantage in terms of motivating a landlord to make repairs because they want to keep getting that subsidy from PHA. Unfortunately, right now, it sounds like I called the hotline last week. It sounds like they are not doing inspections. They expect to go back out for inspections after May 4th. But if you are having an emergency, there is an email that you can contact. It's clientservices@pha.phila.gov.
So I think that's a good segue into the next part of the conversation. So COVID-19 has changed a lot of things for a lot of people. How has it directly affected, one, the ability to get repairs done or people's ability to request repairs? I know that you just mentioned that inspections are not being done right now at this time. So what should people know about emergency repairs or just repairs during COVID-19?
Yeah, this is a tough question, right? So even for people who have subsidized housing, there still can be like additional expenses related to the pandemic or issues that you might be having with making your regular rent. I know we're looking at thousands, maybe even tens of thousands of people who are struggling to pay rent for April and now May. So we are really in a very difficult spot just in terms of the normal landlord-tenant interactions. And when you add on top of that, like needing repairs done, it can make it even more complicated. So we are very interested in those types of cases and advocating around them here at Community Legal Services. We do encourage people to contact our hotline, which Kadeem went over, to get individualized help. But we do recognize that this is an especially difficult time, not just because of the rent issue, but also on top of that, the concern about having people come into your home and make repairs while we are being told not to have people sort of interacting with each other and really be shelter-in-place orders.
So I know that two possible avenues that people do tend to go through to get repairs done are either filing a complaint with the Fair Housing Commission, which I think we talked about briefly. Can you touch a bit more on that process, and then we'll talk about licensing and inspection and where they are at this point?
Sure. So the Fair Housing Commission, I don't think we've covered it before in the Tenant Tuesdays, is that right?
We talked about it briefly, but I don't think we've covered it before, so you can feel free to expand on it.
So, feel free to cut me off, but so this is typically, we're thinking about our private tenants who are seeking a little bit of help because they're not able to get the repairs done that are needed. So obviously documenting that request for repairs, contacting the landlord, giving access. But even then, if a landlord's refusing to make repairs, we do have some additional resources through the Fair Housing Commission. What is the Fair Housing Commission? It's a local or citywide commission that was set up sort of try to help give a forum where there's some oversight into these repairs to avoid landlords from simply evicting, not making repairs, and then putting another tenant into the property, kind of getting back to that affordability crisis that we're currently in.
So the Fair Housing usually does the hearing process, which is temporarily on hold, subject to the governor's stay-at-home order, but they are in fact taking complaints via the web. You can go online. There's not a specific form that you can fill out your complaint to return or repair issue that you have with your landlord, and they will, as soon as things are back operational, convene a hearing to address that with both parties. So talk to me about when a tenant should take the step of repairing and deducting from their rent, or even withholding rent from their landlord.
Good question. Yeah, I think that comes up very quickly sometimes. I think The biggest sort of, so where are we, what are we talking about? We're talking about private tenants. Typically, um, in these types of conversations, we're talking about withholding rent. With subsidized tenants, this is a different story and sort of a longer conversation. But with private tenants, when the landlord's refusing to make repairs, sometimes we immediately jump to, well, I'm going to withhold rent. Um, what we'd like to do is try to have a conversation sort of first about what our goals are as a tenant, which means sort of thinking through that we are sort of living in this situation where we have a little bit of an affordability crisis. We want to make sure that we have some other options just in case this sort of landlord-tenant relationship doesn't work out. So that means sort of having a better understanding of what else is out there in the market. Now that's difficult advice to give right now because obviously we're during a pandemic and we can't be sort of looking for other places physically, and it's sort of limiting our options for moving out. So that is sort of complicating that advice again. But I think in general, if you've made the request for repairs, you've documented those repairs, the next step is that we try to escalate as a private tenant to contacting license and inspections. They are a city agency that, among other things that they do, they come out into residential properties to actually review the property and cite violations of what's called the property maintenance code. So this means if there are repair issues that are significant, then they will be cited by license and inspection. And then that is designed to motivate the landlord to actually make the repairs. So it's another escalation step. What it does for us as tenants is it gives us documentation and sort of backup. It's like someone else coming in and saying, hey, I agree with you. You know, this sink not working, that's an issue. Or the heat not being on, that's an issue. So it helps to escalate. Once you have the L&I violations, it's usually at that point that we would start having a discussion about what withholding might look like. Withholding rent is a significant escalation. It is generally, once you start withholding even a portion of your rent, which you can talk more about, it generally escalates the relationship to a point where a landlord is looking to file in court or pursue an eviction. Of course, that's further complicated right now. As we're talking through this, you're now realizing that as landlords can't file in court, it then perhaps pushes them towards other actions, which would be considered illegal evictions, which we covered in the last conversation.
So I think you raised some very important points just there in that chunk. And I think it's important to kind of take a step back and re-emphasize a couple of things from the perspective of an attorney practicing in municipal court. There's this concept of you've got a repair issue, you've written a letter to your landlord saying, this is what my issue is. You have to allow a reasonable period of time for your landlord to make that repair. So if it's the middle of winter and you don't have heat, that is considered an emergency repair. Theoretically, if it's in the summer and there's something wrong, your central air system is not working, that may be considered an emergency repair. If you've got a leak in your bathroom that's causing damage to, let's say you've got a 2-story, it's causing damage to the roof above your first floor, that's creating mold, that can be considered an emergency repair. But if you've just got, let's say, a broken lock, one of the burners on your stove doesn't necessarily work at its best, those are repairs that you should notify your landlord of in writing and give your landlord an opportunity to make that repair. So if you've got an issue, let's say we are now at the 20th of April, if you discover today that, let's say, something's wrong with your back door to get out into your yard, and you notify your landlord of that in writing today, you have to allow your landlord to receive the notice that says, I have this repair issue and I would like you to fix it under the implied warranty of habitability. And then you also have to give your landlord the time to get a contractor out to your property, determine what the adequate repair is, and let that process work. And you mentioned that you can call license and inspection, which is the city agency that basically regulates rental properties. It tells a landlord, or it tells a tenant that your landlord has a property that is suitable to be rented. There's that certificate of rental suitability that should have been included when every tenant moved into their properties. It's a CRS from the city. It says, your landlord doesn't have any restrictions or liens against the property that will inhibit or limit their ability to rent it to you. So that should have came with the property. So a second function of L&I is to police the status of housing in Philadelphia. So they will come out and they will inspect for significant repair issues. If there's mold, if there's electrical issues, all of those types of things, L&I will come out and cite your landlord for. And you are right that at that point you can start withholding rent, because it usually takes about 20 to 30 days for L&I to come out from the day that you filed that initial complaint. And that will be considered a reasonable time period between you giving your landlord notice of an issue and L&I coming out to your property. So it's important for people to be aware that if you've got a repair issue that started today, the next step tomorrow is not automatically withholding rent. You have to give your landlord an opportunity to remedy the issue. And if he attempts to remedy the issue and still persists, you should let him know you made a repair, it hasn't worked, the issue has reoccurred. And if it's happening multiple times, then you can take that additional step of withholding rent. But you have to give your landlord that opportunity to make those repairs, and also call L&I and give them an opportunity to come out, because the most important thing when you walk into a courtroom as a tenant who has been withholding rent for repair issues is to be able to show the court or your landlord's attorney or advocate that here's the issue, here's when I documented it, here's what I presented to my landlord, and here's what has happened or hasn't happened. Because the onus is on you at that point to show that you have complied with the law. So I think that's a very good conversation to have. I think I want to kind of shift a little bit to an sort of like an emergent conversation, and something that's usually at the back of our minds, but I think is more pertinent right now as people are trapped in their homes subject to the stay-at-home order. We know that Philadelphia has recently expanded their lead law to protect, it would be most children at this point, I think everyone up to the age of 12, and that protection is now in place. Can you walk me through what the general existing protections are and what people should be on the lookout for?
For sure. Do you mind? I just saw a question in the Q&A that related about license and inspection.
Sure, let's do this. Let's answer the first question first, which says, what should be done if a partner moved in without being added to the lease? And I think the correct answer to that would be check your lease terms and see if there is a limit to the number of people who can live in your house. If it says that your capacity is 1, you're the only person who's supposed to live there, then you are subject to a potential eviction process on the basis of your lease. If your lease says you and your family, you can bring someone else in. The best thing to do would be, when someone's moving in, especially if it's your partner, you should notify your landlord that this additional person is now living at your property and your residence, so that your landlord is aware of that. Now, if you've got roommates and your roommate has moved in a partner and that person is not on the lease and therefore not paying rent, that's something that you can raise with your landlord, because it's technically a violation of your lease term. And if that person damages the property or does anything in violation of your lease, you are responsible for your guest and your roommate's guest as someone who's co-signed on that lease. And Tony, do you want to take the L&I question?
Yeah, and a wrinkle on that question too is, I'm curious what you think about this, Kadeem, because what if, it's interesting to find out why that person moved in. Was it like COVID related? Was it related to the pandemic? Was it a need to shelter in place? I don't know what you think about that.
So I think if it's COVID related, and this is probably more important for people who are in subsidized housings that are more strictly regulated. If you've got, let's say, a child who was in college, away at school, and now has to move back in, you should inform your landlord or the housing authority right away. My daughter or son is now living with me because they're no longer at school. School does no longer provides housing. This is the situation. It hasn't. If it's changed your income, you should report that change in income just to avoid any confusion. And also, if they have moved in and your income has also been reduced and you've got an additional mouth to feed, you should also report that change. So I think proactively reporting those types of situational changes, and if it's temporary, let them know that they'll be here for a month, 3 months, whatever the situation might be, just so that everything is on the up and up.
That's a really good point, especially with colleges closing.
And I think the next question says that if L&I determines a home to be uninhabitable and the tenant is told to leave the home and therefore causing homelessness. So I'll let you start, Tony, and then I will add to that.
That's a multi-layered question, I think. Often when I'm talking to sort of tenants who are obviously in private agreements, we're talking about like renting from a private landlord, there is a concern that by contacting the city or license and inspection, have someone come out, that there's this possibility that this inspector could say that the property is uninhabitable. What does that mean? It could be like structural damage to the property. It could be like a risk of a roof collapsing. And that's a real concern. I think I can't say it's impossible. I will say that my experience with L&I inspectors is that they do generally try to have an understanding of who's living in the property, what their options are, before doing something as drastic as declaring a property as uninhabitable and basically saying that everyone has to leave immediately. That's something, unfortunately, that we've seen with rooming houses or houses where there are multiple people living in rooms and the property is not zoned or licensed appropriately, so that it's not sort of a legal setup. Unfortunately, that's been sort of more common that at least I've seen. Of course, I can't say that inspector coming out won't sort of call the property uninhabitable, but we do try to balance that with the reality that it's generally better to get that sort of backup of getting someone to come out from the city and verify that there are these repair conditions. So we don't want to scare people away from using these services.
So I agree with you. And what I will add to that is that habitability is a spectrum. So just because that you have a repair issue or a structural issue at your home does not mean that an L&I inspector will come out and render your property uninhabitable. You could even have an electrical problem and they will give your landlord the opportunity to fix that problem and remedy it. And then if that hasn't been done, L&I has their own court process with the landlord before the property is declared uninhabitable. Now, there might be certain emergency situations where because of the design or setup of a home, it is not safe for multiple people to be living in it as it is. And that's kind of something that's out of our hands. Because you won't actually legally be evicted, you will be told to leave on the basis that it's unsafe. And our job is to connect you with resources, whether it is a temporary shelter or helping you get connected with rental assistance so that you can move into a more safe and habitable environment. And if it does come up that you have been told by the city to remove out of an unsafe property and your landlord then decides to take you to court and try and process an eviction against you, those are one of the instances where you should automatically call the Philly Tenant Hotline and ask an advocate to do an intake with you and run you through the paces and see if you're eligible for legal representation, because in that instance, that's a case that we would want to see and want to be able to advocate on your behalf for before a judge and hopefully get that case removed. Can't guarantee legal representation or legal outcomes, but those are the types of cases that we advocate for the tenant on the tenant's behalf in. I think there's one more question that came in from an anonymous attendee asking about if you are in violation of the number of occupants in a lease, what should you do besides preparing for an eviction? So just to clarify, if there are more people than should be in a residence or than are allowed in a residence does not automatically mean that you will be evicted. It means that you are legally in violation of your lease term. but I think you should still reach out to your landlord and communicate the nature of your situation, because there's a lot happening right now, both in the city, in the state, and nationally, that might cause people who don't typically live together to be forced to live together. So communicate that proactively with your landlord. And if it's that your landlord wants to have this person added to the lease, that's a conversation that you can have with your landlord. But you shouldn't assume just because you've got a COVID related family emergency that causes maybe, let's say, your mom, your brother, your sister, whoever it may be, to be staying with you, and maybe they're staying with you for an extended period of time. That does not automatically mean that your landlord will file against you in eviction court. You should proactively communicate to them, I've got this situation, this is what it is, and this is how I would like to come to an amicable resolution on that issue.
Yeah, I would add just that after you communicate, like following up with any sort of like letter, an email, or even a text confirming what the new situation is. And it's also, you know, we're in a very different world right now with the pandemic, and that up is down and down is up. You know, there we're hoping, and we will advocate, hopefully going forward, that in these types of situations, we really can have people without a place to stay because of the public health emergency. So there are some very good reasons that people may be needing to shelter somewhere. That being said, as Kadeem was talking about, you know, a landlord may not agree with you, but if you try to be as reasonable as you possibly can and explain the circumstances and document it, that can be something that can be helpful if it does end up in court and the court's open.
I agree. So Tony, we've got about 10 minutes left. So I wanted to quickly introduce the topic of the conversation of lead law and lead protections, because schools are closed, children are home, children are running rampant, if that's the correct term, in the home. And then there's this underlying conversation of lead, because Philadelphia does have a particularly old housing stock, and that makes it more susceptible to having old lead paint either in your living area or just in the basement or all other areas where you might have access to. So can you walk us through what the current lead law protections are?
For sure, yeah. Just so people have an understanding, lead paint, or a lot of reasons, it was used in a lot of different chemical interactions up until fairly recently, and it's found to have some very negative effects on people's health. For that reason, the city passed an ordinance saying that properties that fall into certain targeted, they're called targeted dwellings, or certain properties, has special protections, and that a landlord's required to issue what's called a lead safe certificate. So the current legislation we have right now in place, which Kadeem was actually mentioning, that's been improved, and I think those protections go into place later this year. I'm sure we'll have more time to talk about. But if you like, I can go through really quickly the targeted housing.
I think we should go through the targeted groups, what type of housing and information that people should be aware of.
So I'm going to review this sort of targeted housing categories. But overall, what this means is that if you have all of these pieces, which is only 4, which means that you're renting in a property built before 1978, which is a lot of properties in Philadelphia. You have a child aged 6 or under, and you entered into your lease after December of 2012, and you don't have any type of rental subsidy like Section 8 or a voucher. At that point, the protections that are in place are that the landlord has to hire a qualified contractor to complete what's called a lead test. And we can talk more about the test, but that that contractor inspector then issues what's called a lead safe or lead free certificate. And your landlord has to give you a copy of that. So that's like overall the protections are in place, and that's to help prevent lead poisoning, which is, as many people are aware, something that can have sort of effects throughout your life. It can be a very debilitating
So I would add to that to say that children are particularly susceptible to lead poisoning. That's why the current law now covers people under the age of 6, and it has been expanded. That will come into effect later this year. But I think the important thing for tenants to be aware of is that if the things that you can control, having a child under the age of 6, moving into a property or signing a lease post 2012, and you're not receiving a a rental subsidy, whether it's Section 8, like a Section 8 voucher, those are the things that are within your kind of sphere of knowledge and ability to control. And if you fit into that category and your landlord hasn't provided you with a lead safe certificate or a lead inspection report, you can request that inspection and the report from your landlord, because you are supposed to be living in housing that is lead free, because the law does not allow them to rent to adults with children under the age of 6 without getting this lead safe certificate. And if you are in that property and you have a child who you believe may or may not have been subject to lead poisoning, reach out to your child's pediatrician. Make sure you set up lead testing so that they can see whether or not there's actually lead present in your child's blood. That, of course, opens a different private right of action and legal claim that may be present based on your individual situations. That's something that you definitely want to go ahead and do the testing for, and then call the hotline, and we can evaluate that on a one-on-one basis, whether or not that is applicable or that's the actual situation. But the important thing is to know that if you're in a home that's built after 1978, you've got a child under the age of 6, you signed a lease after 2012, and you are not receiving a rental subsidy, the lead law does currently cover you. And I think it's really useful information. It's now more than ever because everyone's at home for longer periods of time, and there might be additional exposure, or there might be exposure that did not previously exist because of the nature in which you had been using your home before the lead exposure, before COVID-19 forced the stay-at-home order to be in place. So that's just general information for people to have. So in the last 5 minutes, I kind of want to pause and see if anyone else has any questions, any of our participants, any issues that you want us to cover before we go into a quick recap of the issues that we've talked about so far.
Just to follow up on that last point as well, a lot of regular doctor visits are being delayed right now because of the pandemic. People are both concerned about going to hospitals, and hospitals are themselves delaying regular appointments. So we do want to encourage folks who have children ages 6 and under to reschedule those when they possibly can, because that's actually how you'll find out, or those tests are done. And if there's any way possible, obviously right now is very difficult, but make sure to put that on your calendar to follow up. And the reason is because of the increased risk of exposure, because now we're all sheltering in place.
I 100% agree with that point. So I'm going to recap quickly with your assistance, Tony. Right now, the courts are still closed through May 4th, not in the month of March, or in the month of May. May 4th is the first day that the courts could theoretically reopen. We are watching to see if that changes, but right now, no evictions can be filed and no lockouts can occur until after May 4th. If you are the victim of an illegal lockout, or if your landlord tries to remove you from your property without you having first gone through the court process, that is considered an illegal lockout, and the police department will assist you. Call 911 or call your local district office, and they will assist you in filing a complaint. If you are actively being evicted, they will dispatch someone out to your home to come and help you mediate with your landlord and hopefully resolve the issues. As we did talk about, in terms of a timeline for people who believe that they may become subject to an eviction process, your landlord has to first file a claim against you if you've never been through the court process. And then there's maybe about a 3 to 4 week window from the day your landlord files an eviction to you actually potentially showing up in court. And then you have the ability to negotiate with a judge with your landlord, with a mediator or an advocate through the Philadelphia Eviction Prevention Project to work on an outcome that theoretically avoids an eviction, so that you are aware that those are your options. If you do get a judgment against you that requires you to move out of your property, there's a minimum 21-day protection after that judgment before you can be locked out of your property. As we talk about repair issues, important things to remember is that we are still under an active pandemic, and there's a shelter-in-place order and limitations on the ability of lots of businesses to operate right now, but emergency repairs are still being permitted. Roof leaks, plumbing leaks, hot water, tank replacements, those types of emergent issues are still being addressed by your landlord. If you have an emergent issue, contact your landlord or your maintenance provider and let them know that you're requesting that emergency repair. If you've got a general repair issue, note what type of housing you live in. If you're in a subsidized housing project, there's an independent process that you should go through with your building maintenance and your housing provider to get that. If you have a private landlord, you can note your repair issues, take pictures of the conditions, send all of that information to your landlord ahead of time, and make sure you give your landlord the opportunity to make that repair before you take the next step of starting to withhold rent. You are always welcome, and you should, if you need to, call licensing and inspection out to come to the property and see what the conditions are so that they can note that they have made a visit and given the landlord a notice of what the repair issues are outside of you putting the landlord on notice, and then giving your landlord the opportunity to make those repairs. And that is additional evidence that you will have in court if you do take the steps to withhold rent on a forward-going basis at any point in time. Make sure you have those ducks in a row. And just briefly, as we mentioned, there is a lead law that protects children under the ages of 6 living in properties that were built after 1978 and leases that were signed after 2012, and there is no subsidy, whether it's Section 8 HUD or through the city, coming into that property. There is that law that protects you. And this is a time where children are spending more time in the house than they usually would. So we just wanted to raise that initial issue for people to be aware of. We will be back next week with another edition of Tenant Tuesdays at 2. We will be talking about the CARES Act and the changes and protections that have been put in place by the federal government, who that applies to, how to find out if it applies to you, and what you should do in those situations. We thank you for joining us today. This has been a presentation of the Philadelphia Eviction Prevention Project in collaboration with Community Legal Services. If you have a legal matter and you would like one-on-one legal advice or information, please call our hotline 267-443-2500, and someone will return your call within 24 to 48 hours. If you just want to go and look up resources, www.phillytenant.org is our website that has lots of resources in different languages for tenants as they not only navigate COVID-19, but just general information that they should know about their rights living in Philadelphia. So I'd like to thank you, Tony, for joining me and being my guest this week. And thank you to our participants for your questions and for listening to us. And we hope to see you back next week. Thank you all. Bye.